Hello, everyone. This is a continuation of reading Appeal Docket number 28. This appears to be the conclusion of the support letters for Schaefer Cox, as well as letters from Schaefer, Suzanne Lee Elliott, and Robert John. I just need to finish this document up before I go on to the next document. My goal is to read all the pro se documents within Schaefer's appeal case, which if you go to pacer.gov, it's 13-30,000 is his appeal case number. This is the conclusion of the document that has all of Schaefer's support letters that I read previously. It says, conclusion: unlike many defendants that come before this court for sentencing, Schaefer Cox's livelihood was not based on crime. He didn't steal or sell or use drugs. His actions were not based on greed. He has no history of violence. He always had legitimate employment. He paid taxes. He went to church. It appears that the jury found that he went from being an overzealous and outspoken government critic to one who crossed the legal boundary into criminal territory. However, he never actually engaged in any violent acts toward the government or any individual. What the jury never heard about Schaefer Cox was that he was making his outrageous statements. He was mentally ill, and that his illness was a significant force behind his conduct. As to future dangerousness and treatment, Dr. Ledoux writes, Mr. Cox needs mental health treatment for the rest of his life. He needs to be protected from people who instigated and supported his delusions, and his needs to be monitored closely to ensure he is taking the appropriate medication. These goals can be well achieved outside the range of a long prison term. Mr. Cox, rather than being a domestic terrorist, is a man with a severe mental illness, whose grandiose thoughts, disorganized and delusional thinking, and less than helpful acquaintances placed him in the position in which he now finds himself. Hopefully the court will consider the factors raised in this report and consider an appropriate sentence for Mr. Cox that would include close adherence to all requirements of a mental health program. A sentence of 10 years to a man who has never been convicted of a felony offense or been to prison is a harsh punishment, made even more so because Mr. Cox has 2 young children he will not see except in prison visiting rooms for many years. Moreover, Cox is in need of mental health treatment that will be difficult to receive in a prison setting. Upon release, he will be a convicted felon. Such a sentence is sufficient, but not more than necessary to achieve the statutory sentencing goals. Dated this first day of January 2013 by Peter Camille. There's a footnote at paragraph 223 of the PSR under section regarding factors that may warrant a sentence outside the guideline range. It is noted that while the defendant's conduct was serious, no actual physical harm to targeted victims occurred. To date, it is not clear that the defendant understands how his conduct could have resulted in physical or psychological harm to others. Moving on to the next section of the document. This is from the Law Office of Robert John. Fairbanks, it's P.O. Box 73570, Fairbanks, Alaska 99707, phone number 907-456-6056, November 12, 2013. It's to Suzanne Lee Elliott, attorney at law, 1300 Hogue Building, H-O-G-E Building, 705 2nd Avenue, Seattle, Washington 98104-1705, related, Schaefer Cox, suppression and dismissal issues, jury instructions, right to testify. Dear Suzanne, since our conversation, I have taken time to update the research I did in relation to the motion to suppress and to dismiss at docket 172. As you are faced with the daunting task of digesting the mammoth record and then determining what to include in the appellant's brief, I have attached copies of the memorandum I drafted at docket 172, Schaefer's corresponding affidavit, and the supplemental addendum filed at docket 234. The following are my thoughts on the suppression and dismissal issues in view of my research through November the 9th, 2013. I have included my observations on a few other issues as well. I hope you will find at least some of them to be helpful. One thing that surprised me about the government's response to the motion to suppress and to dismiss was that the government made little effort to dispute the facts. There was no affidavit from J.R. Olson, $300,000 whore, or anyone else to dispute what Schaefer said. Perhaps that is not surprising, since the government's own records evidence the trucker ruse and Schaefer's exhausted state at the time. In any event, because the government bears the burden of proof, at least as to the warrantless search and seizure issues, and Schaefer had thoroughly articulated his actual and reasonable expectations of privacy in see United States versus Cervantes, 703 F.3D, 1135, 1141, Ninth Circuit, 2012, United States versus Vangse, 594 F.3D, 1111, 1119, Ninth Circuit, 2010. Okay, expectations of privacy in his affidavit. And there did not appear to be a dispute about the underlying facts. We did not request an evidentiary hearing. As I recall, when we argued the motion to the court, AUSA Scrocky, Serpent Scrocky, did not address the issues in the motion, but instead went on and on about what a dangerous man Schaefer was. Having now updated the research, I continue to be struck by the fact that the actions of $300,000 whore J.R. Olson in restraining Schaefer to Fairbanks are above and beyond anything I've found in an invited informer or other government agent being allowed to do. $300,000 whore Olson certainly must have panicked when Schaefer announced he was leaving on February the 19th, 2011, but $300,000 whore Olson's desire to save himself from punishment cannot justify $300,000 whore Olson removing the battery from Schaefer's vehicle and perpetrating the trucker ruse to keep Schaefer in Fairbanks till March the 10th. The two cases and the treatise I cited in the supplemental memorandum indicate that a ruse premised upon misrepresenting the government's agent's purpose negates the necessary consent where the misrepresentation involves duress or coercion or otherwise prevents the individual from fairly assessing the need to surrender his or her privacy. Although a subsequent Ninth Circuit case appears to undermine somewhat the arguments I made about $300,000 whore J.R. Olson's warrantless audio and video recording, the Fourth Amendment arguments involving invited informers and consent by deception remain sound. As to dismissal of charges on October the 23rd, Ninth Circuit, United States versus Black, 2013, 573-4381, F.3D, Ninth Circuit, 2013, thoroughly reviews and discusses the outrageous government conduct doctrine in the Ninth Circuit and includes a stinging dissent. I think that a strong argument can be made that the government's actions towards Schaefer through $300,000 whore Gerald J.R. Olson and Bill Fulton substantially exceed the bounds permitted by the Black court. Just as Judge Noonan's dissent in Black emphasized that the government should not be allowed to lead its citizens into temptation, I would argue that the government should not be allowed to seize or kidnap its citizens into temptation. From the conversation, it is my understanding that you have concluded that there is a sentencing entrapment issue in the case. In that regard, a recent Ninth Circuit case indicates that at least in certain circumstances, sentencing entrapment must be determined by the jury and not the court. At the oral argument on the motion to suppress and to dismiss, Judge Bryan, to my recollection, ruled that Schaefer's entrapment by estoppel claims would need to be decided by the jury. Since I was not at trial, I do not know what evidence was presented as to how, if at all, the jury was instructed on entrapment by estoppel or sentencing entrapment. At the time of the hearing on the motion to suppress and to dismiss it, it did seem to me that Schaefer had at least a colorable entrapment by estoppel defense as to the homemade silencer and perhaps as to the weapons placed in his possession on March 10, 2011 as well. Among the other potential issues in the case that come to mind are the jury instructions relating to the conspiracy. I did some research and helped Nelson draft an instructions that indicated that one could not be guilty of conspiracy where the object or condition upon which the conspiracy would come to fruition did not exist or had no possibility of occurring. A final thing that comes to mind at this time is a call that I got from Schaefer during trial. Schaefer told me that Judge Bryan would not let him testify except through questions elicited through Nelson. I did not then and have not now researched the issue, but it seemed that if under United States Supreme Court decision in Rock, the right and the decision whether to testify are the accused and not the attorneys either to assert or waive. An argument could be made that the accused's assertion of the right to testify should not be fettered to the questions his attorney chooses to ask. In conclusion, I hope you do not find it presumptuous of me to offer so much input into Schaefer's appeal. He is my friend. I am most concerned about the dangerous precedent and threat to liberty set by the government overreaching allowed so far in this case, and I have devoted an extensive part of my practice to handling appellate matters, state and federal. Ultimately, the decision of what to pursue on appeal is yours. As an experienced and distinguished appellate attorney, my hope is that this makes your decision-making easier and increases Schaefer's chances of prevailing. If you have any questions, do not hesitate to call or otherwise contact me. I plan on being out of the office from December the 21st through January the 12th and will be extremely busy to get things done before I take off. But I will make every effort to discuss Schaefer's case with you or review drafts of the brief if you are interested. Sincerely, Robert John. Okay, I think I'm going to pause here and upload this individually. Robert John is the guy to communicate with if you want a legal update. Schaefer has said very positive things about him. He's a lawyer that got everything dismissed at the state level in Alaska, but for some reason he was not engaged at the federal level. His email address, to the best of my ability, to the best of my knowledge, is rjohn, rjohn @gci.net. So I wanted to, let me upload this video as a letter from Robert John to Suzanne Lee Elliott. Okay, take care, everyone.